Okay, CFCSA. Broadly speaking, there are three major components of the CFCSA. After a child goes into care with social workers, that is, the child is removed from their parents, they're put in care, and the first of the three stages is called the presentation stage. Presentation stage is a court appearance that happens within 7 days of the removal. It's summary in nature. The director has to write a report on what's called a Form A, explaining the reasons for removal. And it's kind of a shoot first, ask questions later. They only have to show that there is reason to believe the child was in need of protection and that no less intrusive measures are available to protect the child. So reason to believe a child is in need of protection is a very easy burden of proof. It's like the opposite of beyond a reasonable doubt. That is any reason to believe, even if the child's not in need of protection, if there's a good reason to believe it, that's sufficient. And no less intrusive measures, meaning like if there was not enough food in the house, you can't just order food. Like you have to actually physically remove the child because of a safety concern. Protection concerns are enumerated in Section 13 of the Act, and they're usually physical in nature. Emotional harm can be a basis, but it has to be tied to an established consequence, such as an anxiety disorder that has resulted from the emotional harm. It can't just be speculative or presumptive. It has to be concrete. Effectively, the child protection concerns are basically a safety net that's on the far end of best interest of the child. Children are not going to be removed simply because bad parents are being bad. There are many dysfunctional households with horrible parents that probably emotionally harm their children, where the children are not going to be removed. To get to the point of removal, it has to be a serious protection concern. At the presentation hearing, then, if the party consents, it moves to the second stage, which is the protection hearing, and that is to commence within 45 days of the presentation hearing. So that's stage 2. At the protection hearing, it goes to the protection hearing either within 45 days after the consent, but if the party opposes the presentation hearing at stage 1, there has to be a trial, which can take longer, and then the 45-day clock doesn't start until the trial is finished. So it's often in clients' best interest to just consent at the presentation hearing stage, because in addition to the low burden of proof, which is reason to believe the child's in need of protection, any conflicts in evidence are resolved in favor of the director. So if the parents can bring new evidence, but anything they bring, like the director says the parent was under the influence of drugs and alcohol, the parent can't say, no, I wasn't. That conflict in evidence will be found in favor of the director. However, the parent could bring new evidence saying, I had a prescription for whatever drug I was under. That would be different. That's not a conflict in evidence. That's additional evidence, okay? So most of the presentation hearing stages go by consent, unless there's just a complete mistake on the part of the ministry, and that does happen. I would say about 2 to 5% of cases oppose at the presentation hearing. That's just my rough guess. I don't have stats for that. Most consent, because you have a better chance to just wait your 45 days, and if you want to contest it, go to the protection hearing, stage 2. Now it's balance of probabilities. Is the child in need of protection? It's no longer reason to believe. The director has a much higher burden of proof at the second stage. They have to show that it's more likely than not that the child is in need of protection. Further, conflicts in evidence now are weighted on the balance of probabilities. They're no longer resolved in favor of the director. The one area that kind of gives an advantage to parents at the presentation stage is the less intrusive measures. That language doesn't exist at stage 2, although it's always something, if you can propose a less intrusive measure to protect a child while having the child returned, courts and the ministry do lean toward returning children. It's presumed that the family is the best place to be primarily responsible for the safety and well-being of children, and that is found actually in Section 2 of the Act, in the guiding principles. It states that the family is the preferred environment. In addition to Section 13 protection concerns, Sections 2 and 4 are really important. Section 2 includes the guiding principles that I mentioned. Section 4 is best interest of the child, which is slightly different from the enumeration of best interest in the Family Law Act. Again, the CFCSA, Child Family Community Service Act, is more concerned with protecting kids, not putting them in the best case scenario. If it were looking at best case scenario, then there would be a lot of policy considerations where children removed from impoverished homes and placed with more well-off foster homes could arguably be in better circumstances with the foster home if you went by the FLA's best interest of the child, but that's not in the spirit of the act. We're not intended to give children the best home. It's intended to get them home with their parents if possible, and then only be removed if absolutely necessary. So again, the CFCSA is there to be a safety net, but not a barbed wire fence. Following the second stage, which is the protection hearing, it then goes to the third stage, which is the continuing custody stage. This could also be a transfer of guardianship, Section 5401. The continuing custody test is found in Section 49. And at the third stage, this is actually the easiest stage for the parents to win. So now the burden of proof goes in their favor. The director has to show that there are no significant likelihood that the circumstances leading to removal will improve within a reasonable period of time, or that the parents are unable or unwilling to care for the child. With respect to the first part, no significant likelihood means that if you can show any significant likelihood of improvement with respect to the protection concerns, you don't even have to show that they've improved yet. You just have to show that they will likely improve within a reasonable period of time. It's easier for the parents to show. For example, if there's addiction issues and the parent is in treatment, that would be a basis for a reasonable likelihood that circumstances will improve within a reasonable period of time. With respect to the second part, the parent is unable or unwilling to care for the child. That usually pertains to being like physically unable, like if the parent is not in the province or has suffered a serious brain and spinal cord injury and just can't physically care for the child, or has decided that if they're unwilling, they're just not willing to care for the child. Transfer of guardianship 5401, same test. It's the only difference between CCO and transfer of guardianship is with transfer of guardianship, the director is looking to transfer guardianship to a specific person, whereas under a CCO or continuing custody order, they're just looking to put the child in a pool for potential adoption. Or in the case of some delegated agencies like VACFAS, which is for Indigenous kids, they will do a CCO and just keep the child basically in care without adoption. But it does terminate the parent's guardianship. The other big issue to know about CFCSA is access. So Section 55 provides orders for access, and they're usually made after the first interim order, which is at the presentation stage. The conventional wording for an access order is reasonable access supervised at the discretion of the director. What that means is that the access between the parent and the child should be reasonable, but the director has discretion about whether or not that access is supervised. The director does not have discretion about what is reasonable. It's up to parents are allowed to challenge that if the director does not provide reasonable access. But the director typically does have discretion over supervision. Sometimes if there's no agreement about access, the court may order specified access terms, like 3 days a week or et cetera, et cetera. Post CCO, however, access is the exception and not the rule. Once a parent's guardianship are terminated, the presumption is that they're not going to have any more access, particularly if such access would jeopardize the likelihood the child will be adopted. Essentially, a CCO means the parent is out of the picture and will not see that child again. All right, so that's the summary of the 3 major stages of the CFCSA, along with the access, which is a theme throughout. Any questions? There's a lot more, but those are the big things, okay?
That was a very efficient rundown. Yeah.